background of the invention. Invention has to be in some field of technology. If the invention does not fall within a field of technology, then it is not something what we call a patentable invention. Invention should fall within a broad area of technology. Now, if you want to look at the different kinds of areas of technology, you could find that there are as many streams of technology as there are technologies themselves. So when you describe the background of an invention, and background of an invention is essential for us to understand, to figure out where in the scheme of things will an invention fall in. So the background of an invention will describe the field of the invention. We will come to a moment as to what the field is. And it would also have a description of the prior art. Now, the broad areas of technologies could be mechanical, it could be electrical, it could be chemical, it could be biotechnology, it could be computer science, or it could be any other field of technology. Now, you will notice that this is similar to the departments in a higher technical institute or an engineering college. This also reflects how the patent office is structured. Patent office has dedicated staff and officials who will be dealing with different fields of technology. So if you file a patent for a mechanical application or an application covering a mechanical invention, then it would be examined by a group of examiners who have domain knowledge in that area. Once a patent is filed, then it is assigned to an examiner with the relevant technology background. Invention covering the electric lamp, and we had mentioned this in our earlier lecture. This is the best copy that we have. Earlier, they used to just mention the field of invention and the background of invention in a very broad statement. In this case, it is mentioned that have invented an improvement in electric lamp and the method of manufacturing the same. Over time, now this is the television system, again a patent that we have covered earlier. The invention here, the statement starts, the invention relates to television apparatus and process, that is, it is directed to an apparatus and process for the instantaneous transmission of a scene. So this is what the invention related to. In essence, they are describing here the field of the invention. And then they move on to describe the prior art. Hitherto, attempts have been made to transmit an image. So that gives the background of what has happened in that domain. Now, this again is a 1927 patent. This practice has evolved over the period of time. And this is a patent for the post-it, the adhesive in the post-it. Now, you can see the background of an invention. There is a caption calling it the background of the invention. And here it starts with the field of invention. The field of invention, as technology progresses, would become very, very specific. Now, here the field is the invention relates to inherently tacky, elastomeric, solvent dispersible, solvent insoluble, acrylate copolymer, and a process of preparing the copolymer. The copolymer is the glue in the post-it. Now, here they describe some amount of what can be called as a description of the relevant art or the prior art. Now this, over a period of time, the statement of background of an invention has evolved. This is just to show that the modern patent applications have a much more detailed, depending on the topic, description of the background. The background will also describe some of the problems or the gaps in knowledge. For instance, here you will find that despite the desirability of inherently tacky elastomeric polymers, which are solvent dispersible, solvent insoluble, and of uniformly small size, such a product has never therefore existed. So they are showing a gap in the field of technology, a gap in the description of the prior art, which makes the invention a much sought for invention. There are a couple of things you need to bear in mind while describing the background of an invention. The Indian law requires you to show technical advancement. So you have to mention what was the problem in the prior art, or what was the deficiency in the prior art. We just saw an example of how that was done in the patent covering post-it, and then show what is the contribution of the invention. You should resist the temptation to make a comparison with the prior art, because comparison with the prior art is what the patent office would do to invalidate inventions. So a comparison with the prior art is done to see whether there is novelty or lack of it. It is again done with the prior art to see whether there is inventive step or lack of it. Now, this, if you present the prior art and make comparisons to the invention, your invention, then it would be very close to invalidating it, because you have kind of made a comparison between the prior art and your invention, and an examiner who examines your application or a controller may find it to be obvious. So resist the temptation of making a comparison to the prior art. Now, the background in the US style, as we have just seen, has two parts. That's the field of the invention and the description of the prior art. In Indian applications, there could be some liberty in this format. You could follow a separate field of invention, can be a separate heading. We'll show you some examples of that. And background of invention can also be a separate heading. There are no strict rules for that, but this is allowed as a freedom in drafting.